Judgment and order, I think one.
In view of the above, we do not find any legal infirmity or illegality in the judgment and order of the court. And hence the appeal is very merit. Okay.
Mr. B.K. Marx has. Okay, he's not a senior counsel.
My lord, I'm not saying, man, he will appear, man, in this.
Where is Vakalatnama?
Man, Vakalatnama will be fine.
Where? Why should we allow? He's nowhere. He's not a, he's an engaged counsel.
But man, he will appear, my lord, by Vakalatnama, my lord, and yes, Uduri also, my lord.
What is your name?
My lord, S. H. Shikdar, man.
His name is Zen.
Okay, right. Mr. S.H. Shindar, learned counsel. Okay. Submits on behalf of Mr. P. Right. On the prayer of Mr. S.H. Shindar. This is the matter. When?
My lord, and next week, my lord, and any day, my lord.
This is the matter after a week.
My lord.
Hello.
Right.
Please, Lordship, I beg to mention item number 20.
20.
Yes.
Yes.
Committed the adjournment slip earlier.
Okay, right. Adjournment prayer has been made on behalf of Mr.
I have seen.
No, no,
On
NJ
behalf of NJ Das.
NJ Das, another mic is free. It is not objected to by Ms. Guyan, learned additional to. Accordingly, the matter is adjourned
For 2 weeks.
sorry,
I'm very first.
Ms. M. Burman, legal aid counsel, affairs person. Deeply applied.
May I please, your lordship? I beg to mention for listing, your lordship, on one IA, my lord, suspension of sentence, my lord.
When?
Next week, any date, my lord. Blessed.
This is your lordship. Lordship, I beg to mention item 22 of the Delhi list.
On the prayer of adjournment made on behalf of Mr.
AK Choppy, appearing on behalf.
File for admission.
May it please your lordship. It is a statutory jail appeal conviction under section 302. Let the appeal may be admitted, your honor. And there is also,
Who are you?
I'm for a legal aid counsel.
You are appointed?
Yes, your honor.
Where is your appointment order? How come? How come you are appointed?
As a legal aid
You-
counsel.
You drafted this appeal?
Yes, your honor.
Okay. Miss
As Kataniya.
S. Katania, learned legal aid counsel. For the. Appellant submits that the impugned judgment dated 24/4/2020. Passed by the learned sections Judge Kamrup Aminga. In sections case number 228 of 2015. Arising out of Boko PS case number 24 of 2000. By which the appellant has been convicted under section 302. I think should be set aside. Admit the appeal, call for the TCR.
This year, Lord.
Huh?
This year.
TCR, call for the TCR. We have to be politically correct now. This.
Your honor, there is also an IA for suspension.
Miss A. Begum appears, Leonard PP appears for the suit. List the matter after 4 weeks. Then in the IA, you write, if A. Begum, Leonard PP is granted 4 weeks time to file written objection to the application under 430. DNS.
Then six.
Madam, your legal aid counsel,
Yes, lordship.
what is your name?
And Hassan.
N.
Hassan.
Hassan. Leonard counsel, Leonard legal aid counsel for the appellant. Submits that the judgment date 22/1/2025 passed by the Learned Sessions Judge Qatar in sessions case number 76/2020. convicting the appellant under section 302 IPC to this effect. Admit the appeal for the PCR. Issue notice returnable in 4 weeks. Ms. K. Begum, additional PP except notice on the other state. This is the matter proposed. Then the same order for the IA, huh? Same order. 4 weeks, I didn't know.
Sir,
May I please, your lordship, this appeal against judgment order dated 28/5/25, my lord. Passed by the learned special judge,
And
Kavi
Mr.
D. Bora, my lord,
D. Bora,
under section 4 of POSCO Act.
learned counsel for the, 6 is also there.
Yes, my lord.
Learned counsel for the appellant to submit that the impugned judgment dated 28/5/25 passed by the court of the special judge, South Salmara Mankachar in special bracket P, bracket close, case number 54 of 24 arising out of Mankachar PS case number 6/24, by which the appellant has been convicted under section 4 bracket 1 of the POCSO Act and section 366A IPC. With that effect. Admit the appeal, call for the PCR,
My lord,
issue notice returnable in 4 weeks.
my lord.
They become additional PP except notice from behalf of the state. Notice be served upon the respondent number 2.
My lord. There's also an IA, my lord.
Huh?
There's also an IA, my
Just a
lord.
minute, just a minute, let us finish the order.
My lord. Sorry, my lord.
Notice be served upon the respondent number 2 through the office of the PP and the OC of the concerned police station. The appellant shall accordingly submit what? Soft copy? Over. Soft copy of the appeal to the office of the for onward submission to the OC to serve notice of order respondent number. This is the matter of the 4 weeks. Then in the I, same, 430, same thing, huh?
My lord.
Same thing. 4 weeks.
Keep your blessing.
Okay, the same.
estimates,
That's it. Statutory appeal file
Mr.
in
B. Fugan,
B for com.
Lance Counsel for the appellant. Subject that the impugned judgment. They said. (15/5/25) passed by the court of the learned Sessions Judge Taradio in sessions bracket S-C, case number 187 of 2012, by which the appellants have been convicted under section 302, 149 and 202 IPC to be satisfied.
Appellants were not convicted under section 202 IPC.
Okay, only 149.
Only 149 and 302.
Okay, 202 is correct. Admit the appeal, call for the LCR. Same thing, issue notice, returnable in 4 weeks. Is A Begum except notice on behalf of the state. This is the matter of the 4 weeks. Then
I
I the same order, 4 weeks time. Matter.
till 9 for orders.
May it please, my lord. Lordship, I am appearing on behalf of learned amicus, Mr. M.K. Borua.
Yes,
So we may be furnished with the paper book of the instant case.
the paper book has to be made first. Right, parties are present, however, no one appears for the response. Now, parties are present except for respondent number 2. The office note dated 10/6/25 states that notice in respect of respondent number 2 has been completed. As the PCR has arrived, registry,
Book is there, Lordship.
paper was there,
I don't, sorry, Lord, no, 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 Lordship.
registry to prepare the paper book. This is the matter after preparation of the paper.
Okay.
This is the matter, it is the matter of 4 weeks. Don't have to prepare it. After 4 weeks.
10 to 12.
Please, Your Lordship. I'm appearing for item number 11 and 12, my lord. We are newly engaged, my lord. We need to file a Kalakrama, my lord, in the course of the day.
I am for item number 10, Lordship.
Okay, so the paper book made in this criminal appeals 24, it will suffice for all the.
Whatever same, out of
Same-
same.
Out of same
Same
judgment.
FI.
I heard Mr.
G. Bora.
NJ Gogoi.
Gogoi, learned counsel for the appellant in criminal 211 of 2024. Mr.
D. Bora, my lord.
D. Bora submits that he will be appearing for the appellant in criminal appeals 74 Act 2024
Yes.
and 121 of 2024, correct?
My lord.
He submits that Wakalatnama will be filed within
Within 2 weeks,
within 2 weeks, right?
within 1 week.
Within 1 week. What about paper book? Has it been
Paper book is
put
there,
in?
Lordship.
Given?
Paper book, we have received there.
But I have not received the paper, because
Okay.
It has about objections and put in into November.
Registry furnish the paper book
My God.
to the counsel for the parties, comma, though Ms. A. Begum additional PP submits that she has received a copy of the paper.
Lordship.
This is a matter for hearing.
For hearing.
for hearing, Lordship.
There is IA also.
I also there, Lordship.
I forward.
For
Suspension
suspension
of
of bail.
The suspension of the.
What do? We dispose of or?
That will be taken to
Let-
the one.
Okay, I yesterday said this is a matter. No, don't say anything in the I, just let it be. This is a matter for hearing after 2 weeks.
Lord.
Obliged.
Obliged.
No, no, I didn't. Obliged.
Yes,
Please, I for my lord praying for suspension of sentence. Learned friend appeared for my lord amicus curiae for private respondent.
May I please, your lordship, I am appearing on behalf of the learned amicus curiae, Mr. A. Bhattacharya, lordship. We have not been served with any copy of the appeal as well as the IA, lordship.
My lord, AP,
You have
copy
not
of the
been
appeal
served
and all documents I will serve my lord available because he other day my lord when I informed him he wanted to confirm whether that A. Bhattacharya is he himself on that day. Oh yes, my lord. Available আছে দে মোৰ কপি কেটা দি দিম মই ফাৰ্স্ট and my lord that I may be heard at any next date man.
anytime, I am ready now also.
Yes my lord because
Lordship, I am just, let me go through the records if your lordship can kindly allow me some time, lordship.
yes sure my lord. Like cycle.
When do you all want?
1 week.
Well, next week, my lord, at any date, my lord, I'll give him all the other documents, evidence and etc. I'll make it. So please, my lord, I'll give it to date.
Okay, right. On the prayer of the party, this is the matter. When?
Next week, what you want, sir?
This is the matter after the.
Let a date be fixed, lordship. Can it be on 7th, lordship?
He's busy because
7th, this bench might have a problem
Then I leave it up to your lordship.
because that.
13th, 14th will be a difficulty.
13,
Otherwise,
14, and
no,
30, 30, 30,
it will be difficult.
12.
12, 12.
Oh, bless me.
This is the matter of. It is, in the IA, huh? You're right?
Man, in
The state has submitted their written objection to the application under section 389 to
Yes.
CRP. Are you filing anything? No.
Yeah, lordship, let me go through. If required, I will file, lordship.
Okay. Mr. A. Bhattacharya. Then counsel for the requirement number 2. Submit that. In the meantime, the number 2 also may file.
In the meantime, my lord, the paper book are not yet ready. It's maybe
You're right.
Make ready.
Then it's a registry to prepare the paper as the TCR has arrived. This is the matter of paper.
Public.
I'm appointed as an amicus in this case, my lord. And the Lojima court's order, my lord, 10-6 says that the notice on the respondent number 2 is also completed, my lord. And the trial court records have been received, my lord. Paper book may be prepared, my lord.
The paper book has to be made.
Yes, my lord.
Okay, right. As per the office code dated 10/6/25. Service in respect of the respondent number 2 has been completed. As the PCR has been received by the registry to prepare the paper. That's all.
Yes, my lord.
What about the IA?
My lord, there is no IA in this case. It's a jail appeal, my lord. It's a jail appeal.
Oh, I have registry to prepare the paper. This is the matter after 4 weeks.
Deeply obliged, your lordship.
My lord, with your lordship, kind indulgence, my lord. As regards to item number 22, today's hearing matter, my lord, without informing us, one of the accused appellant has made a mention, my lord, and it has been fixed on 11. But the problem is that there is an IA wherein a direction from the Honorable Apex Court is also there, my lord. So that interim bail may kindly be extended, my lord.
Give me that item 22. This,
IA 1 is 565.
who was the council who asked for this?
565.
565 of 25.
No, who made this?
Well, one Mr. M. Bissas, my lord, who is a co-accused appellant here, my lord. But without informing and taking consent from us, my lord. So we were not aware. We thought when the matter will reach, my lord, we'll make a mention to that, my lord. Because the in that appeal, my lord.
Just write one thing. Just write in that item 22, just add later.
Because
Mr. Z, learned senior counsel. Appearing
for the accused appellant number 1,
accused
Vipul Day, my lord.
Huh?
Vipul Day.
People day. Submit. They were not informed. That's something that they were not
Yes,
informed.
about
Regarding the adjournment to be applied
Second one, okay.
by Mr.
Well, just pointing out, my lord, actually.
I'm writing this, that I know what happens next time. I am keeping a history of what happened.
Yeah, that's true, my lord. No, my only thing is that in this case, my lord, this accused appellant's daughter is a cancer patient who is a minor, aged about 16 years. So the Honorable Supreme Court actually has granted the bail pending hearing of appeal, my lord. So accordingly, my lord, now he has a date with the appointment with the Calcutta expert doctor. My lord, that date is slated to be held on 18, I believe, my lord. 18, my lord.
We have fixed this matter on 11.
So can it be extended till at least 20, my lord, so that he can go and come back? I have annexed all the documents, my lord.
The matter is to be heard on 11.
No, that can be done, but for the IA is concerned, my lord, because I thought I'll make it point out when that matter will be called for, my lord. But
We can decide everything on 11.
no, we can, my lord. But right now, my lord, one fact remain, my lord, that he has already booked the appointment. He has already booked the tickets also for the journey, my lord. And he will be taking his doctor for that appointment on 18. Let him have the satisfaction of his life also, because his daughter is suffering from lithium.
You see, whether it goes against you or in your favor, we'll
That is one
continue.
aspect, my lord.
Wait, because since the case is fixed for 11, we'll fix it on 11.
That is all there, my lord. Now he has not informed us and mentioned, so we'll inform him about the change of date, my lord.
Till 11, the interim order extended till 11. 11. Just let me see. Let us see the eye.
মাত্ৰ আহিছো যোৱা না বাহিৰত সোনকালে যোৱা In the IA, the Cancer Institute documents are all annexed, my lord. Original IA is 565, then I
Let's
have.
just continue, interim order to continue till 11. As per the observations made by the Supreme Court of India, by order dated 2/24, in SLP bracket criminal number 10927/2020. Attempt is to be made by the court to dispose of the connected appeal within 6 months. The said order was however placed before the court for the first time on 2/6/2024. In view of the adjournment prayer having already been allowed, the matter be listed on 11/8.
Much obliged, my lord.
May I please listen, Lordship? Lordship, I am appearing as a legal aid counsel in this matter.
Mr. Yu Chowdhury.
Lordship, in this matter, Lordship, altogether 6 accused persons were convicted out of the same judgment.
302.
Yes, 302, Lordship.
So now the only thing we are going to make paper book, that's all.
Lordship, the LCR is already been received in connection with Lordship, the other case.
Other cases?
69 of 2025. Lordship may kindly look onto the office note dated 26/6/2025.
Yes.
The LCR has been transmitted in connection with criminal appeal 69 of
So
2025.
this matter, that will be tagged with 69.
Yes, Your Lordship.
Anna? And paper book has been made in that.
No,
69.
no.
Okay, right. Mr. Yu Chowdhury, learned legal aid counsel, appears along with Ms. A. Begum, learned additional people. They submit that as per the office note dated 26/6/25,
What item? One item on a copy.
the PCR has been received by the registry in connection with the connected appeal. That is
Lordship,
criminal appeal number 69 of
it
25.
has been stated transmitted, no, Lordship, not received.
Okay, has been
Yes.
transmitted in connection with the connected criminal appeal number 69 of 2020. So we do not know if it has been received.
Because
Publish
Lordship,
this-
there is a flag F, Lordship. There it is stated that it has been transmitted, not.
So it doesn't make any difference. So it is the same. So accordingly, leave this matter along with criminal appeal number 69 of 2024. Registry should prepare the paper book as and when the TCR is received by.
Lordship, there is an IA that is to be considered after.
We can consider now also. No,
Objection must be filed, Lordship. Objection,
has to be filed.
Lordship.
Okay, next in the IA, Ms. A. Begum, additional PP is granted.
4 weeks, Lordship.
4 weeks time to file, no, this
Obligation.
is a matter of.
May I please, Lordship? Lordship, is an application under
Has the-
PNSS.
The paper book is required or not?
My lord, not required for the suspension of sentence.
No, okay. But for the main appeal,
Yes, my lord, paper will.
so you want to do the written objection
Suspension of
has been
sentence.
submitted?
My lord?
The written objection has been submitted?
Yes. It was, a copy was given to me yesterday.
Oh,
My lord, we have extra copies.
okay. He's in a hurry to do it, okay. Hello? You ready, madam?
Lordship, I'll go through, Lordship, because I also got today, Lordship. 302.
So my lord, conviction has been given under,
302
yes, my lord.
and various,
Lordship, various sections are there, but the highest is 302. So lordship,
all of
first
them 302.
all of them, 302 because 149 is there, lordship. First of all, lordship, may I take your lordship to the FIR which culminated in the conviction.
Is there any eyewitness?
Yes, lordship. But there are two eyewitnesses, lordship. What has happened in this case is that, lordship, there was a cross case. That cross case was not brought to its logical conclusion. And lordship has dealt with a number of cases wherein the Supreme Court has also prescribed the method and procedure in which the cross case needs to be dealt with.
I don't,
Lordship, I'll take your lordship through the judgments. Lordship, may I take your lordship to the FIR first, lordship, which culminated into the current conviction. Page 91, lordship.
page 91.
Lordship.
You see, but if you go minutely on all the issues, then we'll be basically deciding the appeal.
No, my lord, I will not be appreciating the evidences. I'll try to satisfy lordship on the procedural aspects. May I read the FI lordship? Page 92. Respected sir, I have the honor to state that there has been a dispute between my father Amrit Mohan Nath and accused persons over the issue of land properties since a long time back. Under such circumstances, around 7:30 am on 9/9/2008, when my younger brother Sri Sapparnath reached the front of GS quarters situated at Muktachara Part 4, while coming back at house along the PWD road, the accused persons in a body and armed with deadly weapons all of a sudden and owing to the earlier grudge, attacked my said younger brother Sri Sapparnath, made assault on various parts of his body, including head by means of arms, with the intention of killing him and thus caused grievous injury to him. Having heard the hue and cry when my father Amrit Mohan Nath, the deceased person, and Sapparnath's wife Shri Krishna Rani Nath, went the place of occurrence, the accused person assaulted them too by means of arms, causing grievous injury on various parts of their bodies, including head, fell them to the ground and then left. Currently, the injured persons are undergoing treatment at Silchar Medical College Hospital. Then my father Amrit Mohan Nath died around 8:30 p.m. on 10/9/2008 while undergoing treatment at Silchar Medical College Hospital. The names of the witnesses will reveal in the course of the investigation. I therefore earnestly pray to your good self to be kind enough to investigate the matter and take necessary action in regard and oblige. So my lord, the incident had taken place on 9 September 2008. This FIR, my lords, was registered on 11th.
11/9.
11/9, lordship. In the meanwhile, lordship, the applicant number 4 here, the applicant number 2, had lodged another FIR on 10th.
Just a minute.
My lord.
No, this FIR has been lodged by whom?
By the daughter of the deceased.
What is her name? Aarti.
Aarti Nath, lordship.
PW?
PW1.
And another FIR has been lodged by?
By the lordship applicant number 2, Ashish Nath.
Who is he?
Who is the accused in this case?
Okay.
The convicted, lordship. Appellant.
FIR lodged by appellant.
Appellant number 2.
When?
On 10th, lordship. 10th of September 2008.
Against whom?
Against these persons, my lord.
Against the deceased.
Against the deceased and both the PWs.
Against deceased.
Deceased and lordship, this Krishna Nath.
PW number?
Deceased, the lordship is deceased.
No.
PW 3 and 4.
Now, what is the relationship of the deceased with 3 and 4?
The deceased, 3 and 4, lordship, the deceased is the father of the PW 4 and PW 3 is the daughter-in-law.
Okay. And PW 1 is the daughter.
Daughter. Right.
So PW 3 is the daughter-in-law.
My lord. Of the deceased person.
Of the PW 4 is the son of deceased. Son of deceased and husband of 3.
Husband of PW 3.
All in the family.
All in the family. Even, my lord, this part is also related to us only. The persons with whom, again, I mean the deceased.
Okay, so So the appellant is, how is he related to the deceased?
My lord, they are all cousins.
How? Cousins is
Elder brother,
elder brother's son.
elder brother's son, my lord.
Son of the elder
My lord,
brother of the
the
deceased.
applicant number 2, Ashish Nath.
No, let us see the appellant
My lord.
is the,
My lord, there are 5 appellants.
no, it's okay.
My lord.
Okay, so appellant number, so 1 to 5,
My lord.
all cousins.
Not all of them.
So give me appellant number 1.
Appellant number 1, my lord.
Let us be very clear on fact.
My lord, my lord. If my lord comes to page number 169, lordship will have an idea as to what the relationship is. 169. This is the FIR which was registered by the applicant number 2, appellant number 2. Here the relationship is described, lordship.
No, it's okay, but I want to know who is the appellant number 1. What's his
Lordship, it's a
name?
bit confusing, so lordship. Lordship will find it here, lordship.
You see, one thing is that unless you clarify,
Lordship.
I do not know. We do not know.
Lordship, the accused, here it states, lordship, the accused persons are my uncle, father's elder brother, aunt, wife of father's elder brother, cousin, son of father's elder brother. This is referring to all the
No, this page 169
lordship.
is the FIR filed by the appellant,
Yes, lordship.
correct?
Yes, lordship.
By which appellant?
By appellant number 2,
Appellant number 2.
Ashish Nath.
This is Kumar.
Ashish Kumar.
And who is appellant number 1?
Appellant number 1, my lord, is Sumanto Nath,
Sumanto Nath.
my lord.
How is he related to the deceased?
My lord, the exact relation could not be ascertained,
But they are related.
but they are related.
Then appellant number 2, how is he related?
Appellant number 2, my lord, it states that his uncle, the deceased was his uncle.
This is uncle. This is his uncle.
And PW3, my lord, is the aunt. And PW4 is the cousin.
She is aunt of whom?
Aunt of this appellant number 2, Ashish Nath.
Aunt of appellant number 2.
Yes, my lord, Ashish Nath.
And appellant number 4,
Appellant number 4 is the cousin
cousin of whom?
of the applicant number 2. Appellant number 2, Ashish Nath.
Of appellant number 2.
My lord.
And number 5?
Number 3, my lord, Sumesh Nath.
Number 3 is the aunt, you said. Appellant number 3 is the.
No, my lord.
of,
No, my lord. The appellant number 2.
appellant number 1.
In the search sheet, lordship will get it, lordship. In the search sheet, appellant number 1, Sumanto Nath. Page number 47. Search sheet.
Look, one thing what I like to do is I want to get the facts clear.
My lord.
Once we get the facts clear, how your job is done.
My lord.
Lordship.
Law is something else.
Page 47, lordship.
That though we can make mistakes, maybe. But facts we should not make mistakes. Page 47.
Lordship. In the name of the accused and address
47 of IE or criminal appeal?
47 of the criminal appeal, lordship. Page 47 of the criminal appeal.
47 of the criminal appeal. Oh. Yes.
Sumanto Nath, son of Mohan Nath.
Sumanto Nath, where? Page 47.
Page 47, column 2. Sumanto Nath, son of
Mohan Nath.
Mohan Nath. Then Lord
No.
Anand.
Who is, no. How are they related to the deceased?
So first of all, lordship, there
What is the name of the deceased?
Amrit Mohan Nath.
Amrit
Mohan Nath.
Mohan Nath. So is Amrit Mohan Nath the brother of this Mohendra Mohan Nath or what?
His
My lord.
father, both father.
No. Amrit Mohan Nath is the brother of Ananda Mohan Nath.
Correct. So if that in that case, Sumanto Nath is the nephew of the deceased.
My lord, perhaps brother, because
Can it be brother? Just now you said Mohendra Mohan Nath is the brother of,
Ananda Mohan Nath. Applicant number 5, my lord. Ananda Mohan Nath is
okay, okay, you said is the brother
of the deceased, Amrit Mohan Nath.
brother of.
So
Then-
perhaps, my lord, the appellant number 1, Sumanta Nath, who is the son of Mahendra Kumar Nath, perhaps will also be the brother of the deceased, Amrit Mohan Nath.
Appellant number 1 is the brother of the deceased. That's what you said.
My lord, appellant number 5, that's on record.
I'm asking about appellant number 1.
Appellant number 1, my lord, it's not on record, my lord, how is he related to the deceased,
Okay, so you don't know.
my lord,
Say that.
my lord.
Please say that.
My lord.
You all are saying something getting confusing.
My lord.
So you don't know about appellant number 1. How is related? You have got no idea.
No. To the deceased person, I don't know.
Okay, then appellant number 2
Appellant number 2, my lord.
is the nephew of deceased.
Yes, my lord, yes.
Appellant number 3 is the aunt of appellant number 2.
My lord.
Appellant number 3 is the aunt of appellant number 2. Correct?
Appellant number 3.
Yes.
No, my appellant number 3, Sumesh Nath.
Oh, then who is he?
That also, my lord.
What they were saying. That's why I recorded this. You see, I am recording whatever you are saying. I am not reading.
My lord.
What I have written is not because of what I have read. It's because of what you have said.
My lord, what I'm trying to establish is.
No, please try to establish one thing.
My lord.
I want to know the relationship of the deceased and the perpetrators of the crime.
What is that family tree as well? Family tree to more level?
Some kind of a chart if we have. that will be-
My lord, I think that a family tree.
Okay, you all don't have it. You all don't have it. Okay. If you all don't have it, okay, so what is your case?
So, my lord, our case is that, my lord, that since this cross case was registered, first of all, my lord, and this was not brought to a logical conclusion. Because, Lordship, the Supreme Court, the Honorable Supreme Court has laid down the procedure for dealing with cross cases, that it has to be heard by the same court, evidence has to be recorded for different cases, argument has to be heard, that case has to be kept on hold. Thereafter, Lordship, the other case, evidence have to be recorded, arguments have to be heard, and two separate judgments have to be given so that, my lord, there is no there is no discrepancy in judgments. Because, Lordship, when two FIRs are there are two contradicting facts of events. Either of them has to be true. Initially, Lordship, it is the IO's responsibility to ascertain which is the correct set of events. It cannot be, Lordship, that two events are correct. So, Lordship, since there is discrepancy, the cross case has not been brought to logical conclusion. So, Lordship, my case is that, Lordship, conviction is very difficult for the conviction to sustain.
In the event the court comes to the same finding,
My lord, but this
In the
cross case has not been brought to a logical conclusion.
supposing it does, then what happens? Then it's all right.
My lord, the matter be remanded back to the trial court. Because this case, my lord, this case has been filed by the magistrate. Surprisingly.
The case has been filed by the
Exactly,
magistrate.
Lordship. The
What?
case we filed has not been defined anywhere in the CRPC.
Huh?
The word case be filed is nowhere defined in the CRPC. My lord, but this is a practice which is going on in the trial courts when the accused are not coming or the witnesses are not coming. Then, Lordship, the case is filed and is again restored to its normal position when the accused is filed or the witnesses are filed. But in this case, Lordship, we had given the magistrate was well aware that there is a cross case in the session court. So, Lordship, the magistrate ought to have transferred the case from his court to the learned session court. That was not done, Lordship.
Okay, this case that we are dealing with,
Lordship.
this has been decided by the Sessions Court.
By the session court, Lordship.
Then what is the cross cases with what?
It was under adjudication before the learned
What
JMFC.
sections of law?
Lordship, under charges were framed under 341, 323, 34.
So that was triable by
JMFC, correct, Lord.
JMFC.
And Lordship, 5 PWs were examined. There were in the charge sheet, Lordship, there were total 10 PWs. Out of 10 PWs, 5 PWs were examined. Thereafter, Lordship, the moment we gave the petition that there is a cross case, so the case to be transferred to the learned session court, Lordship, there was no order passed and suddenly the case was filed.
The case was filed?
Yes, Lordship.
What do you mean the case was?
Case was filed, Lordship. It was put on temporary abeyance.
Which one?
This case, Lordship, the cross case that we had filed
By the JMFC.
by the JMSC, Lordship.
But then out there is nothing regarding 302, so there cannot be a cross finding on 302.
My lord, 302 will only be there when, my lord, there is a motive of killing. But my lord,
No, you see, motive, yes, you see, motive is a word commonly used when the circumstantial evidence is required for proving a case. In a case where there are eyewitnesses to the crime, can you say, no
Pilot,
crime has occurred just because they saw what has happened? No, unless they prove motives, it cannot be a crime.
I understand,
Say
my
that.
lord. But my lord, here the only eyewitness, the star
You said
prosecution
there were
witness,
two.
my lord.
You said there were two eyewitnesses.
My lord, who has witnessed the entire chain of events is only one, that is PW3, and who is accused in this case.
He's accused before this
Before the cross case.
cross case.
Yes, madam.
I'm for the respondent number 2, but my senior is next in code number 25, Lordship.
Well, what to do?
I have instruction right now, so kindly time limit for the matter.
No. If we cannot wait for your senior counsel to give us instructions, this court has to carry on. Unless he has got some other, he makes a request. You cannot adjourn just for that.
Can we take it tomorrow?
Why?
My
What-
senior will appear.
What will we do to tomorrow?
Monday.
Huh?
Monday.
Why?
Um,
Has he told you to ask it? Has he told you that please adjourn the matter for Monday?
Because I'm not, Lordship, my senior is appear on, right now, is doing item 14, code number 25. So I have no.
We will wait for him. He will come. In the meantime, let's do it.
My lord, there is another aspect to it. Non-explanation of non-injury caused to the accused persons. Lordship, this case was filed 323. The informant and the son and his father, they got injured. And Lordship, in the case where I have been convicted, they have not explained the injury as to why that injuries were caused. So Lordship, perhaps when the case will be tried by the same court, all these facts, Lordship, has to be looked into.
I think we'll have to, you see, I think all these aspects will have to be decided in the appeal.
My lord will decide as to whether to remit the.
In the appeal, not in this.
My lord, my lord will decide as to whether to remit the case back to the trial court back or to set aside the conviction. But what I'm trying to satisfy Lordship is that Lordship, since there is a procedure irregularity itself without going into the evidence.
No, I don't know when the charges are framed.
My lord.
On different sections of
My
law.
lord, can I?
302 is not there.
My lord, can I show the judgments? I made a compilation of judgments. In fact, Lordship judgment is also there. One of the judgments.
I was thinking, is it correct?
My lord.
That other case, the cross case,
My lord.
that has been filed by the.
Yes, my lord. It has been kept in abeyance. Yes, my lord. Yes, my lord. Yes. No, my lord. The Supreme Court cases has acquitted the persons, but it is up to a lordship whether. Yes, my lord. Yes, my lord. Yes.
That is kept in abeyance. It is in abeyance.
Case be filed, my lord, is perhaps in abeyance.
File means
Abeyance, yes.
Yes.
So, my lord, the first case I'll be referring to is Mishri Lal. The facts of the case, my lord, starts from page number, para 4, page number 2.
Yes.
The appel of discord has revealed, my lord says it.
Yes.
The appel of discord as revealed by the prosecution's story was over a trivial matter about the passing of bullock cart. The bullock cart of Babulal PW1 being driven by his servant, Patiram PW3 was stopped by the accused in front of the house of Mishri Lal since deceased. Babulal thereafter reversed the bullock cart brought back his bullock cart and reached his house by another route. At that time, Maharaj Singh PW2, uncle of Babulal PW1, Bhavra Singh, the deceased, grandfather of Babulal, and Gopal PW7 and others were sitting in front of the house of Babulal, who questioned as to why the bullock cart had to be brought back by a different route. And at this, Babulal narrated to them the story of stoppage of bullock cart by the respondents. At this moment, accused Mishilal, armed with a farsi, Jamna Prasad, armed with a 12-bore gun, accused Ashok Kumar with a desi katta, and the rest of the accused persons having lathis with them, came near the house of Babulal, hurling abuses, followed by heated exchange of words between both the sides. Then all of a sudden, Jamuna Prasad fired a gunshot at Babulal. The pellets hit him in his legs. The deceased Bhavrav Singh, grandfather of Babulal, tried to save him and stood in front of Babulal when accused Ashok Kumar fired at him with a desi katta, hitting him on the chest. The deceased fell down on the ground and became unconscious. PW2 Maharaj Singh and Karan Singh PW4 also came to save Babulal, but accused Jamuna Prasad fired again, hitting Maharaj Singh and Karan Singh. Accused Madhusudan assaulted Babulal by the lathi, hitting him on the right shoulder. On raising hue and cry, the accused fled away. The deceased Bhavraj Singh was taken to the Kannauj hospital where he was declared dead. Injured Babulal, Maharaj Singh and Karan Singh were admitted in the hospital and treated. Dr. G.D. Kashyap, PW6, sent intimation to the police station, Kannauj. ASI Dhanraj Singh, PW17, reached the hospital and was being reported by Babulal, PW1. ASI registered the FIR, Exhibit P1. The police issued the requisition form of all the injured persons marked as Exhibit P30, P31 and P32. Thereafter, the police case Exhibit P33 was registered on the basis of Exhibit P1. The postmortem was conducted by PW6, embodying the cause of death is from gunshot wound and its mood is syncope. The postmortem report is Exhibit P6. The injury report in respect of Babulal, Karan Singh and Maharaj Singh are marked as Exhibit P7, P11, P12. X-ray plates with regard to the injury sustained by Babulal and Maharaj Singh are marked as Exhibit P8 to P10 and P13 to P16 respectively. Now, Lordship, here is the cross case. The investigating officer also prepared a spot map, Exhibit P3. Accused Mishilal also lodged the report as regards the injury sustained by him. Madhusudan Prasad on the same day, that is 5/3/1987, and over the same incident. The report is marked as Exhibit D8. The police investigated the complaint lodged by Mishilal and challan was filed under Section 147, 149, 147, 148, 149 and 324 IPC and registered as crime number 52 of 1987, which is pending before the learned judicial magistrate first class for disposal. So, Lordship, facts is nearmost identical. Thereafter, Lordship, the 7th paragraph. This is the procedure which is being laid down on how cross cases are to be dealt with. Mary, Lordship. Undisputedly, accused Mishila lodged a report to the police, Exhibit D8, over the same incident happened on 5/3/1987, in which he had clearly stated that the injuries were sustained by him and his son Madhusudan at the hands of the prosecution party. It is also not disputed that on the strength of the same complaint lodged by Mishilal, investigation was also carried out and challan was filed, namely crime case 52/87 under sections 147, 148, 149 and 324 IPC against the prosecution party, which is pending for disposal before the learned judicial magistrate first class. In the said challan, the prosecution story is stated to be an aggressor. This court in Nanthilal versus State of UP 1990, supplementary SCC 145, pointed out the procedure to be followed by trial court in the event of cross cases. It was observed thus. We think that the fair procedure to adopt in a matter like the present, where there are cross cases, is to direct the same learned judge must try both the cases one after the other. After the recording of evidence in one case is completed, he must hear the arguments, but he must reserve the judgment. Thereafter, he must proceed to hear the cross case, and after recording all the evidence, he must hear the arguments but reserve the judgment in that case. The same learned judge must thereafter dispose of the matters by two separate judgments. In deciding each of the cases, he can rely only on the evidence recorded in that particular case. The evidence recorded in the cross case cannot be looked into, nor can the judge be influenced by whatever is argued in the cross case. Each case must be decided on the basis of the evidence which has been placed on record in that particular case without being influenced in any manner by the evidence or arguments urged in the cross case. But both the judgments must be pronounced by the same learned judge one after the other. Thereafter, Lordship, para 8. In the instant case, it is undisputed that the investigating officer submitted the challan on the basis of the complaint lodged by accused Mishri Lal in respect of the same incident. it would have been just, fair, and proper to decide both the cases together by the same court in view of the guidelines devised by this court in Nantilal's case Supra. Now, Lordship, this part is important. The cross cases should be tried together by the same court irrespective of the nature of the offense involved. The rationale behind this is to avoid the conflicting judgments over the same incident. Because if cross cases are allowed to be tried by two courts separately, there is likelihood of conflicting judgments. In the instant case, the investigating officer submitted the challan against both the parties. Both the complaints cannot be said to be right. Either of them must be false. In such a situation, legal obligation is cast upon the investigating officer to make an endeavor to find out the truth and to cull out the truth from the falsehood. Unfortunately, the investigating officer has failed to discharge the obligation, resulting in grave miscarriage of justice. Next, I would like to take your Lordship through the Nantilal's judgment.
There is Supreme Court case. where
Yes, my lord.
Again, is-
Yes, my lord. The same. What is quoted here was extracted from Nantilal's case. Lordship will find in page number 9. The direction is in para 2. This is the exact direction which has been quoted in the other judgment.
Is that your only case? Is that your only point?
My lord, this is the point that because there is an irregularity in the process.
But it does not mean that the order is illegal. Just that
My lord, the order, the trial may not be vitiated, but the
So- so we
conviction may
can-
not be
we
sustained.
can always direct that the other case be also be heard by the same court.
Yes, my lord.
Did this matter?
Yes, my lord.
Hmm.
Then, my lord, the judgments have to be delivered one after the other.
One after the other doesn't mean that what? One after the other means what? 5 seconds apart, 1 month apart, 10 months apart.
My lord, immediately it has to be delivered. It has to be, my lord,
No, you mean to say that the judgment becomes vitiated if it's not delivered one after the other immediately?
no, my lord. What I'm trying to impress upon your lordships is that lordships, if both the cases had been tried together, perhaps lordship, because lordship, this case is narrating a completely different set of events. Our case is narrating a completely different set of events.
So let that case be decided also.
My lord.
Let that case be decided by the same court.
Yes, my lord. So, my lord, if that happens, there is a possibility that 302 might not be there. Because, my lord, there are injuries which have been sustained by me. That has not been explained by the prosecution. They have this onus to explain, lordship, there's a case law on that also. In a murder case, lordship, when I have inflicted injuries, it is their responsibility to prove why I sustained those injuries. Another aspect, lordship, is that conviction has been given under 149. For 149, lordship, one of the major ingredients is 141, that is common object. The reasons of common object has to be recorded in writing. Lordship, but that has not been done by the learned trial court below. Lordship, rest are all
Can we decide that here?
my lord, the other matters, the other grounds that I'll be raising will be appreciation of evidence. So my lords may not take that into consideration. But prima facie, lordships, what I'm trying to again emphasize upon your lordship is that lordship, the conviction may not be sustainable. Lordship will have to see whether the chances of appeal succeeding is very high or I don't have a case. Without appreciating the evidence, lordship.
Lordship, first of all, Lordship, there should be a paper book, Lordship, because to go through the all evidence and all, Lordship, it is not clear as there are two cases, Lordship.
No,
I'll have to go through
basically, he's not on the merit.
that he is on the way that cross
On the-
should be hard,
On the merit, the fact, he's on the law.
Lordship, cross case should be hard by the same court. He's on that.
He's
That can
basically
also be
saying,
done, Lordship, that can also be done, it can be said, whatever.
no, but what he wants at the end of the day is that till it is decided, till both of them, till the process, the procedure is completed, the judgment should be set aside, otherwise this judgment would influence
So
that
it
judgment. That
cannot
is what
be
he said.
settled.
Correct.
Yes,
The eyewitnesses are there, Lordship.
No, no, let the witnesses be there. Whatever witnesses have been recorded, Lordship, that will be there. Argument till argument stage, that will be there. Simultaneously, this case has to be
He's
heard.
only saying
Then
that let the final decision, final judgment and order be passed. In this case, along with that, he says otherwise evidence, everything should remain. Arguments, no need of, maybe arguments, fresh arguments maybe. But besides that, it will remain. In the meantime, it should be settled.
then let it be hard on Lordship, let it be hard. No.
Completely submitted. It is a suicide judgment.
No, let it be hard. Lordship, he is for a
Not friend is, my lord, submitting it is, my lord, totally against law, my lord. For that, your lordship rightly pointed out first time, my lord, for that, my lord, that judgment would not be initiated. Of course, my lord, same court, my lord, would decide, my lord, that case, my lord, one after another. It is decided. That would be decided by the same court. It was not, my lord, exactly consecutively not decided. That would not, my lord, vitiated this judgment, my lord. This is the law, my lord. He is praying for, my lord, two cases were not,
My lord,
my
I'm
lord,
not,
decided one after another by the same court. Therefore, this judgment.
my lord, I'm not
This is
praying
the
for
law,
anything. I'm not praying for the matter to be remanded back. What I'm trying to express and satisfy upon your lordship is that the chances of conviction of my conviction to sustain is very low, is very bleak. Lordship may acquit
I
me,
don't know that.
lordship, because of this procedural irregularity, lordship.
Simply, my
What
lord,
has happened to the other case? It is pending.
It is pending, lordship.
Why haven't you asked, why haven't you submitted an application for quick disposal?
Lordship, because that was being taken by the state. We had filed the case. It was the state's responsibility to, lordship, take the case forward.
No, you can always come to the High Court also saying that it is not being done.
Lordship, that is something on record, lordship, which was not done, perhaps, lordship.
and it is not law, my lord. It is not substantial law. My lord. Supreme Court, my lord, in some cases, my lord, recommended, my lord, that should be good.
No, my lord,
To
there are
avoid
three more
contradictory judgment.
cases,
To
lordship.
pass, my lord,
Let us see the other judgments.
Lordship. Lordship may kindly come to the Kuldeep Yadav Singh case, lordship.
Page
Uh,
11.
Page number, the judgment is a page number 11, lordship.
Okay.
The facts, I'll read from page 12.
No, come to
The law point, lordship, in para 8. Page 13, lordship. On the basis of the further bayan, may I read, lordship? On the basis of the Farad Bayan of the informant Naresh Yadav, FIR number 11/97 was registered with Govindpur PS under section 147.
Come to the main. The ratio decision, where is that?
The ratio, lordship, will para 18, lordship. Para 18, page 15.
Yes.
In the case on hand, we have already noted that investigation was conducted by the same IO in respect of the same incident that took place on 28/4/1997 at Khalihan. Though in our cross case, that is FIR number 12/97, a complaint was made on the next day, that is 29/4/1997 at about 5:30 AM. From the materials available, both the cases relate to the incident that took place on 9 AM on 28/4/1997, which is also clear from the following information. That is so. Lordship may thereafter come to page number 16, para 19. In view of the above factual details, coupled with the statements made by the prosecution witness, and in light of the principles enumerated by this court, the investigating officer ought to have brought to the notice of the trial judge about the two FIRs arising out of the same incident to avoid gross injustice to the parties concerned. Lordship may thereafter come to page 40, paragraph 43. The reasons for acquittal, lordship. Page 21, lordship.
Yes.
Summary of all the issues. Though both the FIRs 11/97 and 12/97 investigated by the same IO, he had not acted in good discipline and not drawn the attention of the trial judge about the cross cases arising of the same incident. By reading the statement of prosecution witnesses under 164 of the code and their evidence before the court clearly showed their improvements with due deliberation, consultation, and in absence of credible explanation, conviction based on their testimony cannot be sustained. Lordship, thereafter, page 22, para G. There is no material to show that all the accused shared in common object, the object itself not being proved,
and their participation,
These are the facts, those are the merits.
my lord. Lordship, thereafter, Lordship's judgment is there. My lord, in page number 51.
In this case, what has been laid down? What is the ratio? You haven't taken the ratio.
Lordship, the ratio is that, Lordship, it has to be tried by the same court. Lordship,
Where is that paragraph?
Lordship, it has been depreciated since it was not tried by the same court. That matter,
Where is that line?
page 16, para 19. May I read, Lordship?
Yes,
In view of the above factual details, coupled with the statements made by the prosecution witness, and in light of the principles enunciated by this court, the investigating officer ought to have brought to the notice of the trial judge about the two FIRs arising out of the same incident to avoid gross injustice to the parties concerned.
It's on a different footing.
My lord, thereafter, my lord's case is there in page 51. Page 51. So, Lordship, here also, but here it was on a slightly different footing. Here, Lordship, what has happened is that the trial court below had passed one single judgment. So, Lordship had indicated that, Lordship, the judgment is patently illegal. Page 58, Lordship, para 13 onwards.
it's slightly different.
It's on a different, slightly different footing. Instead of passing two separate judgments, one single judgment was passed.
But what happens if it is not done as per Mishra's case?
My lord, in Mishilal case, the
If it is not done, then what happens?
they were acquitted, my lord. My lord, how am I getting prejudiced if it is not tried by the same court? My lords may kindly have the case of
No,
Lakshmi.
Where does it say that because of that it is?
My lord, that was one of the reasons. That was one of the reasons why for acquittal. Another aspect, Lordship, I'll also take Lordship through that.
Is there any other judgment? No other judgment.
Lordship, this Mishilal has been quoted in a number of judgments, but Lordship, this is still whole grounds. Lordship, why will it cause prejudice to me?
Okay, basically, what happened?
So, Lordship, according to us, the FIR that we had registered, Ananda Mohan Nath, when he was returning, Ananda Mohan Nath, the PW5, when he was returning from buying fertilizer from one Nipendra Prasad, he was attacked by these three persons, Amrit Mohan, the PW3 and PW4.
And then the quarrel happened.
The deceased.
The deceased, the PW3 and PW4. This is our story, our facts of the events.
PW3 is a lady.
PW3 is a lady and PW4. And then the quarrel happened and all of them intervened, and which ultimately led to the death of the Amrit Mohan Nath. And their story, Lordship, they have two different stories. PW3, because PW3 is the only person who has seen the entire chain of events. In a 161 statement, she's saying something else, and in her evidence, she's saying something else. So, Lordship, that will perhaps go into appreciation of evidence. But, Lordship, what needs to be ascertained is what was the correct facts of the events. Otherwise, Lordship, 302 will not be may not be sustainable.
Let us see her evidence.
My lord. Page 125, Lordship.
No. With page 125 is annexure 8.
Of the IA, Lordship. Krishnanath. My lord. Mary, Lordship.
Where?
I know the informant Aarti Nath, who is my sister-in-law. I also know the accused persons. On 9/9/2008, I was in my house, and on that day at about 7:30 a.m., my father-in-law took my son, aged 6 years, came in front of my house, and that time, accused Anandanath hit my son with catapult gulti. And accordingly, my father-in-law came to my house and reported the matter to my husband. Lordship, I'll pause here for a bit. This part of the incident regarding Anandanath hitting his son with the gulti was brought in for the first time on evidence, because in 161 it was stated something else. And that was brought in the cross also, Lordship. I'll continue, Lordship.
Okay, Anand Nath is you.
Anandanath is one of the appellants.
Okay.
Yes, Lordship. Thereafter, my husband went to the house of one Shishinath to report about the matter. And when he was coming back from the house of Shishinath, on the way, accused Anandanath attacked my husband for assaulting him. And in the meantime, other accused persons, Sumesh Nath, Ashish Nath, Sumantanath, and Sajal Nath, came with weapons and assaulted my husband jointly. As a result, he sustained severe injuries over his body, including his head. Neighboring people saw the incident. On hearing hue and cry of my husband, my father-in-law Amrit Nath also came out to the rescue his son, and while he proceeding to my husband, then accused Anandanath threw something in the eyes of my father-in-law, and as a result, he became unable to see. Thereafter, all the accused jointly dragged my father-in-law to a nearby field, and all of them also assaulted my father-in-law, and as a result, he sustained severe injuries upon his person. When I approached to rescue my husband, at that time, accused Sajal Nath caught me and assaulted me with a dao, and I sustained sharp cut injuries. Thereafter, my brother-in-law Rabindranath arrived at the place of occurrence and requested the accused persons not to proceed further, and then the accused persons left the place. Thereafter, we all the injured were shifted to Lala PHC for medical examination, and after primary treatment, we all were shifted to SMCH Silchar, wherein during treatment, my father-in-law died on the following day of incident, and my father did undergo medical treatment.
How old was he?
My lord, Amrit Mohan Nath.
The person who died?
Postmortem report over, sir. Postmortem report.
My lord, 80, Amrit Mohan Nath. 83 years, my lord.
83 years.
My lord.
And so 83-year and lady and her husband attacked you. Attacked
me, my lord, one person. Amrit Mohan Nath.
83-year-old attacking you must have been a very dangerous situation.
My lord, even I am.
You must have been shivering in your boots. 83-year-old coming at you with one lady.
My lord, but he was my brother.
Whoever.
So I will also be nearly the same age.
Maybe 83-year-old. Have you seen a 83-year-old fight in your life? I just want to, I'm just, really, I mean, thinking about how dangerous it would look. You know, if the old 83-year-old man, his daughter-in-law who's around 40 years old, and the husband come attack me. I mean,
My lord,
they'll
the-
make a deadly trio.
my lord, the point, my lord, the point
The
being
good,
who
bad,
start-
and the ugly. Uh,
My lord, the point being who started the fight, who instigated the, because there was a
you
dispute.
see,
It's on record that,
I can, you see, when you think of private defense also,
my lord,
I mean, it has to be proportionate. Now, how did they attack you?
my lord, they started the fight.
How? Bare knuckles, they came with a crowbar, they came with a dao, they came with their
My
bare
lord,
hand.
according to the FIR, my lord, they came with
And have you
lathi
seen
and-
a lady fight, a normal
My lord, the
lady?
lady did not fight. She was just there.
She was just there.
She was just there.
Did the 83-year-old attack you? How did he attack you? What did he do? Did he use his bare knuckles and gave you a Mike Tyson kind of a wallop or something like that? I don't know. Think of that. I mean, I'm just trying to think of whether your explanation is
But my lord also has to look
believable or
into
not.
another angle, lordship. Who started the fight, lordship? Because it's not about lordship whether he had the ability to fight or not, lordship, but whether he was the party who instigated the whether.
You see, another
entire event.
You see another thing.
Hello.
A fight is very subjective. The word fight. Now, I've noticed in mainland India the way that people fight. It is usually nose to nose, they'll argue for around 20 minutes. And then that they say is a fight. In other areas, unless there is real fisticuffs, it's not a fight. So so you have got to describe how the fight started. What happened?
My lord, may I take you through the witness of PW2
Yes.
of Amrit Ananda Mohan Nath. Lordship will find in page 197.
One PW2.
PW2 in the cross case, lordship.
PW2 is here, 124.
My lord, 197. No, 120. This PW2 is lordship where I have been convicted, but the other case. I mean, my side of the events.
Your side of the event is in another matter.
Yes, my lord. So my lord may kindly have a look to under.
But then no. How can now that is the law. The law laid down in that case. What is that case? That Maideen case.
My lord.
Iti Maideen.
Mishilal.
You cannot look into the evidence of the cross case to come to a finding in this.
No, my lord.
That
No, my lord. I just want to, my lord, appreciate what I'm trying to appraise, lordship, is lordship to get an understanding as to what were the events that actually happened. Lordship had raised the query: how can a
Yes.
83-year-old
yes, but then for that,
lordship?
and I do not know whether your submission is going to be sustainable due to the very fact that in a cross case, whatever evidence is recorded in the cross case, that cannot be used in this case.
It cannot be, my lord.
It cannot be
It
used.
cannot be.
Then,
It cannot be. But
then so the evidence that is the decision that is going to be made
my lord,
in the cross case will depend upon the evidence that is recorded in the
my lord,
case.
my lord.
Might have to be the case might be tried by the same judge, no doubt.
My lord.
But then the evidence of that case will remain the evidence of that.
My lord, my lord.
The findings will be on that case.
My lord, but my lord, what
How can I now rely upon what has been recorded in that case?
because my lord, what was missed by the learned trial court below was the injury that was caused upon me. And that was there in this case, lordship itself, where I've been convicted. One of the PWs has said that all the persons were injured. I mean, the medical reports that are there, they were injured. And the prosecution has not explained the reason for those injuries.
What about in 313? Did you give explanation?
Lordship 313.
Yes, you had the opportunity to give your side of the story.
313 perhaps. Perhaps, my lord. But my lord, this is 2008, my lord.
Correct.
And my lord, what has happened is that, my lord, if I take your lordship through PW3, PW4, my lord, page 128. In page 129, my lord, in the cross case,
Yes.
my elder sister lodged the case. The GR case number 1035/2008 was pending amongst the
Again
accused.
going to the first case.
My lord, no, this is the case where I've been convicted.
Yes.
PW4 is the son.
Yes.
Page 129, my lord.
Yes.
I heard that police sent us to Lala PHC. My elder sister lodged the case. The GR case number 1035/2008 was pending amongst the accused persons and ourselves, and the same was dismissed. So, lordship, perhaps they had given the impression that your case is dismissed. Instead of being filed, my lord, since it was filed, my lord, they are no doubt, my lord, they are not very literate persons and not very accustomed with the process of law. So, lordship, case being filed, perhaps they thought that their case was dismissed.
Which case?
The one that the cross case. This is what the PW4 is stating here.
I'm not finding how this is going to help you.
My lord, ultimately, my lords, I'm getting prejudiced because of one aspect, that I had sustained injuries, and that was not explained by the prosecution. The same was in the case of
So have
Mishilal
you-
also.
Have you filed any application in the cross case that it should be heard by this judge who had this?
Yes, my lord. Yes.
Chief,
I
as
did.
is, my learned friend is saying about the cross case, lordship. According to their cross case, their PWs, lordship. May I read the PW of their cross case, lordship? PW1, a cross case. It is on page number 130 of the criminal appeal, lordship.
Yes.
I am the informant, cross case, lordship.
Yes.
Complainant in this case, accused Swapna Nath is my cousin, son of my father's elder brother.
130 where?
Of the main appeal, lordship.
Okay. Yes.
Son of the father's elder brother, and the other accused is his wife. The incident took place around 7 to 8 a.m. on 9/9/2008. I remained engaged in my agricultural works. At that time, my father reached the front of the house of the accused person. While he was coming back to house carrying fertilizer, accused Swapna Nath, Minarani Nath, and Amrit Nath, the deceased lordship, and Srimati Rani Nath detained him on the road and assaulted him and fell on the muddy land beside the PW road. There was a quarrel, he fell down. Then I came to the place of occurrence in a run. When I tried to save my father, they assaulted me too. When accused person left, I took my father to the police station and lodged an azhar. Means he was fit, lordship. As he have gone to the police station, lordship, and medical examination of the injured was done, and I made my statement, police executed so and so. In the cross, lordship, Amrit Nath, the father of the accused Swapna Nath, died after sustaining injury. It is his lordship, his cross.
My lord, that is on record. One person has died. That is a fact.
That also, lordship,
So who assaulted this deceased? No one. He died by himself.
My lord, in the fight, my lord, that is what, my lord.
But there's no fight out here.
My lord, may kindly have the
It's the
witness of
lordship, it is
PW.
hard one by one, lordship.
Lordship, PW, the outrage is PW1 says,
My lord.
then I came to the place of occurrence in Iran. When I tried to save my father, they assaulted me too. When the accused person left,
My lord.
I took my father to the police station. Amrit Nath, the father of accused.
They went to their house, then when the deceased lordship came with his son, then again this person attacked them, lordship.
No, my lord, what has happened
It
is
is-
that, lordship, these three persons, PW3, PW4, and the person who has died, they tried to pick up a fight and they assaulted Ananda Mohan Nath. That picture, Lordship, becomes clear from a bare perusal of the PW.
No, okay, so they assaulted, then what happened?
So, Lordship, then the others intervene,
Who intervened?
the other appellants.
So you all intervened.
Lordship. Because, Lordship, there is,
But that is not reflected here in this evidence of PW1 in the cross case.
my lord, eventually it does. In PW2, it does. Page 135. Read, Lordship. The incident took place around 7:30 a.m. on 9/9/2008. I went to the fertilizer shop of Nipendra Roy of our village to bring fertilizer to apply on my paddy field. As soon as I came out of the shop after purchasing fertilizer, my nephew, son of elder brother Swapan Nath, came there and started hurling abuses at me.
Lenja?
Dark, my lord, one, my lord, iron, my lord, like a knife, my lord.
Okay.
Yeah, my lord, in front of my lord, steel.
And started hurling abuses at me after detaining me there. Swapan Nath, with the assistance of his father, caught hold of me from both the sides and then assaulted me by means of lathi and lenja, and I fell down there. Swapan Nath assaulted me by means of lathi, and his father Amrit Nath pressed my neck with lenja. So it was Swapan Nath, Lordship, the PW4, who actually did the assault. I sustained injury on my back, and my right hand got broken due to the assault made with the lenja. Having seen the incident, when my son came to my rescue, Swapan Nath assaulted him too by means of lathi in his hand. Having heard the hue and cry, my daughter-in-law Jyotish Nath, Lordship, the PW3, daughter Sipra Rani Nath, sister-in-law, wife of younger Mukti Rani Nath, younger brother Sumanta Nath and his son Sumesh Nath came to the place of occurrence. Lordship, this is how we all came to the place of occurrence. The accused fled therefrom. The wife of Swapan Nath was present at the time of occurrence and she assaulted me by means of, it's not clear, Lordship. My son and nephew took me to Lala PS from the place of occurrence in injured condition. And so far, Lordship, the medical injury sustained by us is concerned, Lordship, will find that in
This letter must be heard one by one. One this
That
side,
is
then
correct.
it will make some.
You have been in jail for how long?
Lordship, for 351 days.
Oh, not even a year.
Not even.
Lordship may kindly consider the case for applicant number 1 and applicant number 5. Lordship, they are almost 90 years plus. Rest, Lordship, I repeat
But
to Lordship.
all,
For the age, Lordship.
applicant number,
Applicant number 1 and applicant number 5.
how old are they?
Lordship, applicant number 1 is
80 years, okay.
80 years and applicant number 5 is also 80 years. Lordship, both of them are the brother of the deceased. So Lordship may kindly consider their case.
Yes, anything to say?
Admitted, my lord, fight between the parties, my lord, and the person died in the incident, my lord.
But this 80-year-old, the two of them, applicant 1 and 5, their family actually the property dispute.
Yes, my lord.
That was on record, my lord. The dispute is there from a long time. That is going on for a long time. That both the sides have admitted to this proposition.
My humble submission is that, my lord, this is not a case for bail, my lord.
80-year-old people,
But
I
they do not care their age, my lord.
they do not care, but you see, I don't think even if an 80-year-old tries to hurt you, he can hurt you. He might have the intention, but
They should, my lord, they respect their own age, my lord.
huh?
They should respect their own age, my lord.
No, they should. You see, the body will not respect. The body will make sure that they remain that age only.
Yes.
You know what I'm trying to say is like you see, I play badminton. Then now what I could do when I was 35 or 40, in my mind, I can still do it. But I know when I play that I cannot do what I used to do earlier.
Yes.
So the body is not willing to behave as you think you are. So these 80-year-olds might be still thinking they are like Dara Singh or something like
Yes,
that.
my lord. This is
But,
happened, my lord.
most probably, they'll be just about managing to walk here and there.
Correct, my lord.
Yes.
But you can't say some of them are, on the other hand, you had that Punjab marathoner who died at the age of 104 or 14, 4. He was hit by a speeding Scorpio. Marathon.
My lord, those were exceptions. Generally,
Those are exceptions. Exceptions that prove the rule. Murphy's Law. Isn't it?
Matter may be hard, my lord, on merit. You think.
Okay, right. Right, Mr. Yes, Mr. Learned counsel for the petitioner. Also heard Miss A. Begum, learned additional PP for the state, and Mr.
AM Borvia for respond number.
A.M. Barbuya for respond number. Respond number
Informant for respond number.
2.
Yes.
For respond number. The present application under section 430 or 389?
430, my lord, BNSS.
430 of the BNSS 2020 is for suspension of the sentence inflicted upon the petitioner by judgment and order dated 16/11/2024. Now, why sentence order is it? Is it a separate sentence order or
My lord, sentence order is separate.
why sentence order dated?
One second.
Can take on a 16/11/24 month.
16/11/24.
It is, my lord, very new one. Only 16/11. Okay.
For 364 days. And this previous custody.
It is not for 364 days.
Yes.
It's okay. Let us decide that.
Yeah.
16/11/2024 passed by the court of the additional sessions judge Hailakandi in sessions case number 79/2015 arising out of what case?
Lala PS case number 317.
Lala PS case number 317 of 2000. The sentence order had been passed on account of the petitioners having been convicted by the learned trial court
I got 90 days.
under section 302 IPC 302 slash what?
149, 325/149.
Huh?
My lord, 148 IPC,
148.
324/149.
Just a minute. It'll be 302 149.
My lord,
Then
325,
325
149.
149.
3
324 149
and 148.
and section 148.
I got 90 days.
The petitioners were sentenced to undergo simple imprisonment of 1 year for the offense under section 324/149 IPC. Comma. No.
2 years.
Huh? No, one.
1 year for 148.
Okay, 1 year for 148. 148. 148. Pusta. They was also sentenced to undergo simple imprisonment for 2 years in relation to the offence under section 324/149. They were also sentenced to undergo simple imprisonment for 2 years with a fine of rupees 3,000 each, in default. Simple imprisonment for 2 months under section 325/149.
3 years, my lord.
3 years.
Oh, no?
3 years.
Yes.
You have written 2 years here
My,
in your page 2. Look at your page 2.
325 3 years.
I'm sorry, my lord. Sir, mistake.
You have written wrongly.
I'm sorry, my lord. It's my mistake. I apologize.
Okay, what is that? Under section 325/149, right, with 3 years, okay, yeah? So they have also been sentenced to undergo rigorous imprisonment for life with a fine of rupees 6,000 each, in default, simple imprisonment for 3 months.
Right.
In respect of the offence under section 302/149, IPC. Next class. The petitioners counsel submit that the deceased Amrit Mohan Nath had expired due to a fight, between his family members and the appellant,
My lord.
who were all related. So he submits that the fight had started. No, he submits that there was a property dispute between, there's a property dispute at the center of the dispute, and it was in that context that a fight had started between. The petitioners counsel submit that Amrit Mohan Nath died due to his injuries on 9/9/2008, and an FIR dated 11/9/2008 was registered by the daughter of the deceased, bracket PW1, daughter of the deceased, namely Arati Nath, bracket PW. The said FIR was registered as Lala PS case number 317/2000. So the appellants have been convicted of the offence under the sections of law enumerated above by the learned trial. Come on. The learned trial court did not take into consideration the fact that a cross case had been filed by
appellant number 2, Ashish Nath.
appellant number 2, Ashish Kumar Nath, by way of an FIR dated 10/9/2008, which culminated into the registration of Lala PS case number
314/2008,
314 of 2008 under section
341, 325, 326, 34.
and 34. I think. He submits that sheet has also been submitted by the case IO in the Lala PS case number. What is that one? Number
314/2008.
314 of 2000. And the same has been registered as in the
GR case number
if
1035/2008.
what case number?
GR
case number
1035
10
2008.
2008.
My lord.
GR number 1035 2008 is pending before the court of
JMFC Hailakandi.
Hailakandi.
Learned JMFC Hailakandi.
And what and the state of the cases
5 witnesses have been examined out of 10.
and the state of the case is that five prosecution witnesses have been examined out of 10 prosecuted. He submits that the accused in GR 1035 2008 are the who are the whole accused persons.
My lord, they are the PW3, 4 and the deceased person.
PW3, PW4 and the deceased person, Amrit Mohanna.
My lord.
Next paragraph. The petitioner's cause is subject that the learned trial court should not have disposed of the Sessions case number 79 of 2015, by which the present appellants have been convicted. In view of the fact that the trial proceedings in GR 1035 of 2008 have not been completed till date. It submits that in terms of the judgment of the Supreme Court in the case of State of MP versus Mishri Lal, bracket head, and others, reported in 2003 9 SCC 426. Cross cases should be tried together by the same court, irrespective of the nature of the offense involved. He submits that the rationale behind the same is to avoid conflicting judgments over the same incident, as there is a likelihood of conflicting judgment if the two cross cases are disposed of by two different
PW3 and PW4 and sir.
Yes, sir. The learned counsel for the petitioner submits
PW2 sir.
that though the charges framed in GR 1035 of 2008 pertain to offenses triable by a court of the judicial magistrate first class, the same being a cross case in relation to Sessions case number 79 of 2015, GR 1035 of 2008 should also be tried by the same court of the additional session judge Calicut.
পড়ে গেছে
Next, the learned counsel for the petitioners for the submission. In terms of the judgment of the Supreme Court, in the case of Nathi Lal versus State of UP, 1990 supply SCC 145. Cross cases must be decided on the basis of the evidence recorded in each of the cross cases, without being influenced in any manner by the evidence or arguments urged in the cross case. However, both the judgment in the cross cases must be pronounced by the learned judge, one after the other. The learned counsel submits that as the same has not been done in the present case, the questions of facts which are to be decided in GR 1035/2008 could be in conflict with the findings of the learned trial court in the case that has been put to challenge by way of the present criminal appeal number 54, no, 54 of 2020. They accordingly praise that till a decision is taken by the court of the JMFC, Hailakandi,
my lord.
Hailakandi, in GR 1035 of 2008.
No, my lord, this case has to go back to my lord session court. JMFC cannot try, the same court has to try.
No, that's what I'm saying.
My lord.
He accordingly submits that he accordingly submits that GR 1035/2008 should be heard by the same sessions court that had decided sessions case number 79 of 2000. Until then, the till then the sentence inflicted upon the appellant/petitioner pursuant to the impugned judgment and order dated. What is the impugned judgment and order?
16/11/24, my lord.
That is, what about the sentence order? Same.
No, my lord.
Impugned judgment and order dated
14 and
16.
16.
Impugned sentence order. No. Impugned sentence order dated 16/11/2020. Should be suspended. According to the appellants, should be allowed to go, petitioners should be allowed to go on bail. Till final disposal of the. That's all. Next one. Miss A. Bega, the learned additional PP. On the other hand, submit that just because Sessions case number 79 of 2015 has been disposed of and it has been put to challenge by way of the present appeal. No. Don't say and. Instead of and, you put comma. And ER 1035 of 2008 has not been disposed of, comma. Does not mean that the impugned judgment and order dated 14/11/2024 and the sentence imposed thereupon on 16/11/2020 has been vitiated. It submits that the petitioner can always file an application to the learned trial court in respect for transferring GR 103, not trial court, it will go to the, I think to the district court, no?
Session court.
To the district and sessions court for transferring GR 103 from 2008 before the same court that had disposed of sessions case number 79 of 2015. In any event, there is no grounds for suspending the sentence and releasing the appellants on bail, keeping in view the fact that there is an eyewitness to the crime who has seen the appellants committing the crime in court. That's all. What else?
It may be hard, Lordship.
Huh?
Very.
On merit, Lordship, after hearing the full case, then Lordship may decide. As there is eyewitness, we'll have to go through the witness.
Like Miss A.M. Barbuya, learned counsel for the response number 2, also echoes also reiterates the submission made by the learned PP, additional PP. Next paragraph. We have considered, on considering the law laid down by the Supreme Court with regard to how cost cases should be disposed of. We find at this stage that there is nothing to show that the impugned judgment and order is vitiated due to no final decision being taken by in GR 1035 of 2000. In terms of the judgment of the Supreme Court in the case of Mishri Lal dead Supra, the Supreme Court has held that cross cases should be tried together by the same court, irrespective of the nature of the offenses. In terms of the judgment of the Supreme Court in Nakhi Lal Supra, each case must be decided on the basis of the evidence which has been recorded in each of the cross cases. without being influenced in any manner by the evidence or arguments urged in the court. But both the judgments must be pronounced by the same judge, same learned judge, one after the other. There is, we are humbly bound by the decision of the Supreme Court. However, the fact remains that the court, the learned court will have to, however, the fact remains that the court would have to decide whether there are cross cases and whether, and if so, whether, whether it should be sent to the same court for deciding. GR 1035 of 2000. In this regard, the in this regard, the petitioner would have to move appropriate applications with regard to their stand as the cross cases would have to be decided on. That GR 1035 2008 would have to be decided by the additional sessions judge, Hailakata, who had decided Sessions case number 79 of 2000. Next paragraph. On considering the fact that the can we suspend the sentence only for two of them?
My lord,
Huh?
my lord,
There is eyewitness certificate, if they had a marriage.
80 years. You want me to, you want us to go to the role of those 80 years,
Lordship, he used a caterpillar.
80-year old.
He used the caterpillar to hit the 6-year-old child.
My lord, that was 20 years back.
That is 6-year-old child is a different thing.
No,
6-year-old
no,
child did not die.
That man, yeah, old man have hit the child. What did the quarrel?
This case is not with regard to hitting the child. This case is with regard to the death of the old man.
Then lordship, what the reason lordship? I think.
So it's like this. Supposing
Lordship,
one person is charged with murdering
lordship.
one 20-year-old. You cannot take into account the fact that he slapped a
Sir, it
2-year-old child or a monkey or a dog.
is there lordship. So
That's a
lordship,
different thing.
so lordship, what the accused role is there? So we'll have to go through the evidences.
We'll go now. Let us see the evidence. Let us see
We'll have to.
PW
PW 2, my lords.
to page.
Uh, PW 3, my lords.
Three.
Page 125.
Page.
125.
That's- Who is this? Who is this petitioners? 80-year-old petitioner.
My lord, applicant number 1,
Swantanath.
Anantanath and Anandanath.
Let us see. They came.
Lordship married.
Yes.
I know the informant Aradinath, who is my sister-in-law. I also know the accused person. On 9/9/2008, I was in my house, and on that day at about 7:30 a.m., my father-in-law took my son, aged 6 years, came in front of my house, and at that time accused Anandanath hit my son with a catapult, gulti, and accordingly
My lord,
my
this was 2.
With a catapult, no one can die.
no,
A human being, that is. Bird maybe.
did not die, lordship.
And then it did. Catapult was against the sun, not the
Son.
not the
That-
disease.
Lordship, let me.
Okay.
Thereafter, my husband went to the house of one Srinath to report about the matter, and when he was coming back from the house of Srinath, on the way, accused Anandanath attacked my husband for assaulting him, and in the meantime, other accused person. Anandanath Lordship.
Okay, right, whatever I said. On considering the fact that the appellant, the petitioners, the petitioners number 1 and 5 are both 80 years old as on date. We are of the view that the impugned sentence order. We are of the view that the sentence imposed upon, the sentence imposed upon them by sentence order dated 16/11/2020 should remain suspended. Only in respect of appellant number, petitioner number 1 and 5. They are accordingly allowed to go on a bail bond of rupees 10,000 each. Okay? With one surety of life. To the satisfaction of the to the satisfaction of the what? To trial court.
My lord,
Till the hearing, the final decision of the court.
Actually,
my lord's prerogative, my lord, whatsoever condition my lord was imposed.
to the satisfaction of the learned trial court. Trial court. So, the prayer for suspending the sentence in respect of the other petitioners stand rejected. The IA is accordingly disposed of. Then in the
Highly
main
obliged, my
case,
lord.
in the main case,
In the main case, my lord, paper book was already,
it is back, I think. What a big thick only, no?
my lord.
So you take back the compilation of your
My lord,
judgment.
my lord.
Okay, right, in the main case, you're right. Paper book has come,
No, Lordship.
It was directed to be prepared, my lord, in the last.
Where is there, Lordship?
TCR is there.
Here is there, sir, sorry.
As TCR has arrived, acha, no.
Direction was already
Acha,
there.
already there. As paper book has not been prepared despite the order dated 25/6/25. This is the matter after 3 weeks.
Highly obliged, my lord.
Now you're in no hurry now.
Highly obliged.
I've just come across a judgment. Prioritize criminal efforts of elderly accused on bail, especially when crime is old.
Not only that, there is a campaign now
Yes.
by Salsa.
Yes, yes,
That's why.
yes.
Old and terminally ill. And there are eyewitnesses,
One eyewitness is there.
I think
Accused.
2,
One, my lord.
4 and 9, I
Daughter.
think.
4 is not eyewitness, my lord.
Okay, for now.
9 is eyewitness. Daughter. But there are some, my lord, vital contradictions are here, my lord.
Where? By 9.
PW9, my lord.
Where?
My lord, she has stated that she has seen the last 3 blows, and the last blow, my lord, she has said that the neck about to severed, my lord. But in 161, she did not state anything, my lord. She did not even see the, my lord, assault.
Oh, was this put to the IO?
IO, my lord, who investigated the case,
No,
he expired. Subsequently, some other, my lord, person submitted
Then?
the.
Bad luck.
No, my lord, that question was put to her.
No, you see, that is not the way we can discredit a witness. You have got to put that question to the IO.
Unfortunately, he died, my lord.
Then what happened?
The person who submitted such he was put that question.
Then you cannot say that you cannot discredit the witness there. There's no ground there. Is there, madam? I think you have to put that question to the IO. No? Unless the IO is.
Unfortunately, he expired.
Yes, but you could have asked the second IO who has.
Yes, my lord.
Did you ask him?
Yes, he was asked.
Then what did he say?
My lord, instead of my learned friend is asking, my lord, that.
Learned friend is asking, but you should have come prepared.
Yes. No, I am prepared, my lord.
Then we
My lord,
might
10,
not,
my lord, 10.
we might not need to hear her
10,
at
my
all.
lord, 10.
Page.
PW 10, my lord, page 24.
Yes. Let us see the cross.
Yes, my lord. Cross, my lord, page 25, my lord. Page 25.
Who is the witness 9?
IO, my lord.
No,
IO means the person who submitted
This eyewitness, what is his number?
9, my lord.
9.
PW 9.
What is his name?
Page 22. Daisy.
Daisy Thakuria.
Yes, Daisy Thakuria.
Daisy Thakuria.
Houston.
Huh? Oh, that's at 3 o'clock. Any other? Tuesday is fifth.
Monday also I can do, but I have a date sentence reference in court number 1 if we come, so Monday.
Okay, those company man. Let's do it after the
1 week.
after Independence Day.
Yes, ma'am.
Okay. Right. And the prayer made by Ms. B. Buyan, additional PP, who submits that she has not got the paper book. This is the matter on you, it.
Yeah, I have not been provided with the paper book, my lord, by the office concerned.
By your office.
Yes,
By the registry it has been given.
might have given because they cannot file it without.
Okay. Can it be on, instead of 19, can it be any other day? 21st.
Okay.
What? You don't want me to?
Provided with a copy by the office.
Wait a
concerned.
minute. Let me see what has been.
No, it might have, my lord, they misplaced it, my lord, that's a normal
Yes,
practice.
You have not brought it.
Let it be 26. 26.
Copy technical. Always, they serve, my lord.
Received paper book on behalf of Mr. K. Goswami. Senior advocate. N.K. Kalita. No.
That's me.
He has been
Book bestowed.
appointed in place of Mr. K. Goswami.
Paper book bestowed. So what do we do? What do we write?
They convene to lordship.
So we have to fix the date.
26.
Reasons cannot, all
Huh?
the reasons. I seek for adjournment because
So-
non-availability of the people.
Okay, let's say due to non-availability of paper.
Number is.